Welcome back to Client School. I'm Eric Johnson, a lawyer with the law firm of Utah Family Law, LC.
And I'm Brian Godfrey, a legal assistant with Utah Family Law, LC.
We're going to talk today about well-intentioned but terribly awful legal advice from non-lawyers. And Brian, a couple of things that you thought of.
Well, when people are talking about protective orders, for example, a lot of times people think that, well, when I get a protective order, that's going to protect me, even though the protective order was put against me. Wrong?
No.
Doesn't do that. Those are ex parte.
And things like, well, if it says that I can't communicate with him or her, well, then that goes for them too. Nope.
Wrong.
Nope. You can't communicate with them, but they can communicate with you. And then get this. If they initiate communication with you, you have to not communicate.
Yes.
Because even saying so much as, you have a protective order, I can't communicate, that's still communicating. So what do? If somebody has a protective order against you where you can have no communication with him or her, and that person calls you on the phone, as soon as you recognize who it is, if you picked up without looking at caller ID or something like that, or you on somebody else's phone, as soon as you know who it is, what do?
Hang up.
Well, do you say anything? Isn't that rude just to hang up? Right. Because you're communicating, but if you hang up, you're not.
Right.
Okay? All right. Now, along the same lines with protective orders, oftentimes when you get one issued against you, whether it be a temporary or a permanent, you may at some point try to dismiss that protective order, meaning you have to let the person, you have to get the petitioner for that protective order served, personally served with notice of your motion to dismiss or vacate. Right. Now, who do people think of using when it comes to personal service?
Well, when they think of doing personal service and they think, well, I can just have my friend go do it because anybody over 18.
Which is true. Your friend, as long as it's not an immediate family member, although in some cases that could be more. But basically, if your friend's an adult over the age of 18, that friend could go and serve the paperwork and the notice of the hearing and that sort of thing required by law. Why is that a bad idea?
Well, because if your protective order states you can't have third-party communication, your friend saying anything, even if it was innocent at the time they hand the paperwork, oh, and by the way, your husband thinks you're being a real jerk about all this, that's third-party communication.
Even if you didn't tell that person to say anything. You just say, hey, would you get these papers over to my ex-wife or my wife or boyfriend or whatever? And you say, man, she's a real jerk. If you didn't say and make sure she knows that, if your friend says, here's some paperwork for you, and you know what, your husband thinks you're a real jerk and so do I, that could technically, even though I don't think it really is, but somebody, some judge, some commissioner might see that as a violation of a protective order.
Right.
So the moral of this story, when it comes to protective orders, talk to a lawyer, and don't just talk to any lawyer. Talk to a good lawyer who actually knows protective order law. It's nothing like what you think. And when it comes to service of process or service of notice, make sure that you don't use a friend. Even if the friend is free, even if the friend is willing, use a professional process server or a sheriff's deputy or a constable. These people don't have a dog in the fight. They can't be accused of making threats. There's no reason they would, and the court's not going to buy it if your ex or your boyfriend or girlfriend or husband or wife were to say something like that.
Right. They can just twist things around. It'll blow up in your face real quick.
Moving right along, what's another pet peeve of ours about just people that are well-intentioned, but they're just leading you astray and they can make things even worse and certainly not better?
When it comes to doing your own private investigation work. Now, again, this is something that people can do, but
some of what they can do.
Yes. A private investigator has way more authority to follow someone or take video surveillance, whereas you can get charged for privacy violation, all kinds of things.
There are specific statutory provisions that allow private investigators to do things legally that private citizens cannot do.
Right.
So that's one big benefit. The other thing is these private investigators have experience.
Right.
So here's another thing we think is funny is people say, well, I wanted to save money on a private investigator, so my buddy or my mom, who's retired, decided to follow this person around, and they get made.
Yeah, now they have a stalking injunction because they followed him from the grocery store.
So not only does your ex know that that he or she's being followed because you had an inept person following, that person can also say, I was frightened. So then they can go ask for a stalking injunction. So you've just made things worse, and you never got the evidence you were hoping to get. What else, Brian?
Well, a lot of times people think, if 10 or 20 or 30 people are upset, then bam, we can just get a class action
lawsuit. Hey, is the state of Utah messing with you? Has DCFS done you wrong? Do you have a judge or the whole court system that you feel is against you? Well, you know what? Let's band together and file.
As long as you got 30 mad people.
Federal class action lawsuit. Okay.
Right.
I know that. I guess for some people that sounds really good. Okay.
Yeah.
Federal class action lawsuits are difficult. They are not free. Mm-hmm. So a lawyer who files one has to get paid. And you might say, well, I got a notice that Blockbuster Video had to pay me back, or Netflix was sued, and
Sure.
I was named as one of the class action members, and I got a $1.50 voucher or something like that. Well, yes, but you got a $1.50 voucher. Okay? So if you're part of some class action because you've got a grudge against the state of Utah, DCFS, the courts, okay, first of all, even if that case succeeded, it's going to be relief that is for the entire class, not just you. And if you're hoping to make some money, there are easier ways to make money, including begging for it on the sidewalk. Okay? All right. Now, a couple of other things that we thought just people need to be aware of is that we don't have a problem with people that proceed pro se.
Right.
You know, people that don't hire lawyers.
I've done some pro se.
But I can tell you that the courts often do. And I've seen people that have prepared well and done as good a job as any decent attorney could do and lose. And I'm convinced it's because there's a bias against pro se people. Now, whether you think that's a plug for legal services or not, we don't care.
Right.
We're just letting you know. Find out for yourself, and then you'll say, yeah, you know what, they weren't blowing smoke, they were right. Okay, another thing. Pro se people think that because I'm not an attorney, therefore the rules are different from me. No, they aren't.
Yeah.
So if you come into court and you're unprepared, or you don't know how to proceed, you don't know how to make arguments, you don't know how to get evidence admitted, you don't know how to make objections, you make the wrong kinds of objections, you don't get special treatment because you're pro se. You'll be held to the same standard. Now, in saying that, don't be surprised if sometimes you get cut a little slack, if sometimes the court is lenient. But you can't count on that, nor is it consistent. Sometimes the court will treat you well one day and then treat you terribly the next for the same thing.
It's not worth risking.
Yeah.
Yeah.
A couple of things I think about. People will often come into court and they go, and I have a letter right here in my hand from the principal. Admissible? No. It's, first of all, the principal's not there. Secondly, if the statement isn't a sworn statement, so there's no way to authenticate it. There's a number of problems with that. Now, you know what? To be honest, sometimes you bring in a letter that you claim to be from the principal, and the court or the commissioner might accept it. But other times, your whole case is hanging on this. All you needed to get it done right was just have a notarized stamp on it with saying that this was a sworn statement from the principal, and you'd be in like Flynn. But instead, you didn't know, you didn't do it. You figured, well, no one's going to think that I faked a letter from the principal. Oh, really? Why not? Maybe you did. How's the poor judge supposed to know this is an authentic letter? In other words, maybe your spouse or your boyfriend or girlfriend will admit that, yes, this I'm not going to, I know it's from the principal, I'm not going to argue over it.
Yeah.
But you did it wrong. People don't know how to get evidence in. People will also do this where they will cite the wrong code. I see this all the time in divorce cases where people will cite termination of parental rights law. Now, sometimes there might be a couple of good analogies to draw from that, but if you're citing the wrong laws and the wrong rules in court, you're going to get a sour look from the court at best. And in some cases, the court will just lose patience. We've seen it. We've seen situations where they say, you know what, stop talking. You don't make any sense. We are not here to talk about this today. You're citing the wrong laws, the wrong rules. I won't listen to you. And then these same people come out like, oh man, that judge is prejudiced against me. That judge has it in for me. No, the judge doesn't have it in for you. You're just making an ass of yourself in court, and the judge doesn't have to put up with that. Okay? All right, well, looking at my notes here, what else did I have? Along the same lines, people will say, well, I'm going to talk about how my civil rights are being violated. To hear people that aren't lawyers talk about civil rights, anything that ticks them off is a violation. Yeah, is a violation of their constitutional rights, a violation
not
of their
to say the
civil rights.
Constitution isn't awesome.
Right. But
bring it up the right way.
Yeah, and by the way, constitutional arguments are some of the weakest arguments, quite frankly.
Well, you may as well.
That isn't because I think the Constitution's weak. That isn't because I don't like the Constitution.
Right.
It's just that in order to violate the Constitution, you've got to meet a pretty high bar, and most of the little things that happen to people don't rise to the level of constitutional violations, whether that be the state constitution or the federal constitution. One other thing. People say, I've been done wrong by the court, by the judge. I've been done wrong by my ex's lawyer. I've been done wrong by those DCFS workers. So what's my solution?
I'm going to file a complaint.
I'm going to file a bar complaint against the lawyer. I'm going to file a judicial misconduct complaint against the judge. And I'm going to file a complaint against DCFS. And you know what? People will listen to me. And people will read and take seriously what I say. Actually, they probably won't. Okay? That may or may not be fair. You may or may not be a kook who's just making some rambling complaint that makes no sense. You may also have a legitimate beef. But lawyers, I hate to say it, lawyers often protect their own. Judges will protect their own. DCFS will protect its own. So when you complain, don't expect this to be welcomed with open arms and read with extreme interest. Sometimes they do, but you can't count on it.
Sometimes you're drawing a bigger target on yourself. For example, when you file something against the police department, for example, if you file a complaint with the internal
Don't be surprised if your
affairs,
911 calls don't get responded to as quickly or things like that.
because the
So,
cops look them over.
we wanted you to know about these things because forewarned is forearmed. So a lot of times, if you're getting your legal advice from people who aren't lawyers, and people who aren't competent lawyers at that, you not only may be going down the wrong path, but you may be doing more damage to yourself than good. Thanks for coming to Client School.